Good morning, everyone. My name is Brian Joseph Improgo, and I am part of Group 4. And today, we will be discussing the corporate and ethical issues in the business world. In particular, the issues involving human resources and human resource management. In particular as well, I shall be discussing sexual harassment in the workplace, minimum wage issues, the issue of unjust dismissal, and bribery and corruption in the corporate setting. To begin, I will be discussing sexual harassment first in relation to our national law, which is Republic Act number 7877. A few definitions before we go ahead. What is sexual harassment? Under the law, this is defined as any uninvited and unwelcome behavior of a sexual nature. This is done by a person in authority towards a subordinate. So when we say sexual, what do we mean? Usually, this is considered as any behavior which is sexually motivated or has sexual undertones. And when we say authority, or as the law requires ascendancy, this is the governing or controlling influence. So the confluence of these three elements, the unwelcome behavior by a person in authority, so it's a sexual behavior, there should be authority, and the behavior should be or must be accompanied by a sexual motivation or contains sexual undertones. Under the law, there are two forms of sexual harassment that may be committed. First is the work-related or employment environment sexual harassment, and the other is the training or educational environment sexual harassment. Allow me to focus on the first one in relation to our course. In this work-related sexual harassment is usually committed when a person of authority demands sexual favors or commits acts and behaviors with sexual undertones towards another person, a subordinate, in exchange for something such as privileges, promotions, conditions of employment, favorable compensation, continued employment, so on and so forth, wherein any refusal would usually lead to a discrimination or deprivation of opportunities. Even if the act of the superior or person of authority is within the rights under the labor laws and within the rights of the employer under the labor laws, if such right is tantamount to an abuse, wherein the resulting situation would become hostile towards the victim, or that there is intimidation or the victim is offended, such act would be deemed under the ambit of a sexual harassment act. So, as I said before, this is committed by the employer, employee, manager, supervisor, agent of the employer, or any other person who has this moral ascendancy over a subordinate or a co-employee, and is committed during work hours, in the work environment, or during the conduct of official duties. The difference with the second type of sexual harassment is, well, in fact, they are almost the same in terms of facts and requisites. The difference perhaps is that the person who commits this is usually the person with moral ascendancy, is usually the teacher or school or training employee, a professor, a trainer, and the victim is usually a student with the same attending considerations that the behavior is sexual in nature, the refusal would result to an intimidating or hostile environment, and the agreement would usually result into a privilege or a benefit or a consideration. We have, under the Civil Service Commission rules, forms of sexual harassment as enumerated. It can be in the form of malicious touching, overt sexual advances, gestures with lewd insinuations, requests or demands for sexual favors, and even lurid remarks. The use or the showing of pictures or graphics, letters, even writing notes with sexual undertones, underpinnings, and any other form that is analogous or comparable to the aforementioned. Sexual harassment may happen, as I said, via the following scenarios: in the premises of the workplace or in the premises of a school or training institution. Also, in any place where the parties may be found as a result of their duties or their responsibilities, either from work or from education. So even official business outside the office or school, any behavior of such sexual nature would still be deemed illegal and criminal under the Sexual Harassment Act, even after school or work hours, even at out-of-town conferences, training seminars, even after work hours, if by telephone, cellular phone, or any other electronic means of communication, and during conversation that is work-related, or wherein the relationship is that of a work or education personnel who has authority over the subordinate or student. Such acts would still be deemed under the ambit of a sexual harassment. Furthermore, overt acts that are deemed as constituting sexual harassment is the unwanted touching of private parts, included but not limited to the genitalia, the buttocks, and the breast. Sexual assault, even if not resulting to rape, is deemed sexual harassment. Malicious touching, even if it's merely parts of the clothing, but if it is near or adjacent to certain sensitive parts of the body, even just mere requests for sexual favor, even with no physical contact, if such favor is leveraged against the grant of an employment, promotion, even favorable working conditions, even a choice for privileges for travels, and in school environments for passing a grade, for the granting of honors or scholarship, the payment of the benefit of stipends or allowances, and any other cases which would be deemed analogous or similar to those mentioned. Also, derogatory or degrading remarks, innuendos directed towards these members of the other sex, or reference to one's sexual orientation to describe a person, verbal abuse or threats with sexual overtones, those even unwanted or surreptitiously looking or stealing a look at a person's private part or undergarments, text messages with green jokes. We must be careful of this. It may be innocent from the one who is sending it, but it may be taken as offensive from the one receiving it. Emails and other forms of communication, wherein the result is that the victim is offended or embarrassed, and after advice of the victim to desist from such act, the person sending the message continues to conduct the offensive behavior. He would or she would be liable for the act of sexual harassment. And those minor acts that could still be considered as a form of sexual harassment is malicious leering, or ogling, looking at one person for a very long time or for a good while, causing that person to be uncomfortable. The display of offensive pictures or messages, even those questions or comments about a person's sex life, even sexual flirtation where such advances have been rejected, or person making such advances have been told not to do so but continues to do so. Even the act of making lewd gestures or offensive signs is considered a form of sexual harassment. Even that persistent unwanted attention, yung mga martir na manliligaw, mag-ingat-ingat po kayo, mag-ingat-ingat po tayo. This attention with sexual overtones, when persistent even against the victim's wishes, unwelcome phone calls, causing discomfort, and other acts similar as to the ones mentioned, are deemed forms of sexual harassment. The law provides the penalty of 10,000 to 20,000 pesos per act, per count, and even an imprisonment of 1 month to 6 months, or even both fine and imprisonment on the discretion of the court based on the gravity of the offense. Take note, under our recent jurisprudence, under the case of Tolyonco versus Court of Appeals, sexual harassment, although the law is silent regarding this matter, can be both committed by a male or a female person, for so long as such person has committed the act or done a behavior which is deemed sexual in nature towards a subordinate, or that said offending party has authority over an employee, and in the other case that I mentioned, over a student or a trainee. That is the end of my first report, the end of part 1. Thank you very much.